the essential ingredients of conspiracy were not proved through reliable evidence. 18. Whether justice can be seen to have been done in this case while the appellant was deprived of his right of appeal before the High Court, being tried directly by the High Court. 19. Had he been tried by a sessions court, the trial judge would have been legally bound to follow the case law developed up to the time of trial, whereas the High Court ignored the same altogether. In this case, up to the time of trial and conviction, there was absolutely no precedent of conviction and sentence of capital punishment on the testimony of approver. Neither in the judicial history of this country, murder trial of an accused was conducted by the High Court in its original jurisdiction, thereby denying the accused a valuable right of appeal before the High Court. The trial in this case was akin to the trial of Bhagat Singh, who too was tried, convicted and sentenced in Lahore on the testimony of approver. 20. The judgment is per inquirium. According to Black's Law Dictionary, a judicial decision wrongly made is termed as per inquirium. The very fact that three honorable judges, Mr. Justice Ghulam Safdar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, out of 7 gave a dissenting view, whereas 4 handpicked judges acted under the dictates of tyrant dictator, which makes it imperative for the Supreme Court of Pakistan to re-examine the law on the point of approver and criminal conspiracy. 11. 21. It has been ruled by the Honorable Supreme Court of Pakistan in the case of Federation of Pakistan and others versus Mia Muhammad Nawaz Sharif, PLD 2009, Supreme Court 284, as below. Law is not a static object. It has to cope with the modern ideas and concepts and the disputes coming before the court for resolution, as the society with its environmental setup is continuously progressing. Law as well as its remedies are also changing with passage of time. 22. The question of bias needs to be revisited by the Supreme Court of Pakistan in the light of its judgment in the case of Asif Ali Zardari versus the State, PLD 2001, Supreme Court 685. 23. It was a split judgment of 4 versus 3. 4 convicting judges, that is Mr. Justice Sheikh Anwarul Haq, Chief Justice, Mr. Justice Muhammad Akram, Mr. Justice Karam Elai Chauhan, and Mr. Justice Naseem Hassan Shah, and 3 acquitting judges, that is Mr. Justice Ghulam Safdar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, which needs to be revisited, especially after the admission of more than 1 members of the majority view, judges who, as mentioned supra, minced no words in stating that the judgment was given under undue influence exerted by the government of the day. Whereas it is noteworthy to see views expressed by the dissenting members of the bench concerning the evidence of approval, which read as under. As the prosecution case mainly hinges on the evidence of the approver Masood Mahmood, the question arises as to whether he should be believed or not. An overall examination of his evidence has led me to conclude that it is not of the quality on which reliance can be placed. Not only that, it suffers from inherent weaknesses, but also tends to show that he was a man of conscience, which conduct is wholly unnatural in the background of the facts elicited in the evidence. This feature had opened the gate for the argument as to whether the alleged order given to him by appellant Zulfikar Ali Bhutto to kill Ahmed Raza Kasuri and his own reaction to it amounted to an agreement within the meaning of Section 120A PPC. However, this question has been resolved in the judgment of my learned brother G. Safdar Shah J, and I need not go into it. The High Court has construed the substantial omissions and improvements in his evidence as one of details or omissions of matters which have been brought on record by the public prosecutor by putting specific questions. In my opinion, these omissions and improvements vitally affect his truthfulness, and therefore in resolving it in favor of the prosecution in High Court, the High Court has given an illusory value to his evidence. If I may say so with respect, this was wholly unjustified. For the benefit of doubt in the evidence must in law go to the accused, as that is the elementary principle of criminal jurisprudence. 24. Accused is entitled to fair trial. Justice rushed is justice crushed. No murder case in Pakistan right from the independence of Pakistan to date has finally been decided in such a short span of time as in the referred case. This unholy and extraordinary haste in disposal of this case also clearly demonstrates bias. 25. It is enshrined in the Constitution of the Islamic Republic of Pakistan that it is one of the prime jurisdiction of the Supreme Court of Pakistan to do complete justice. Article 187, Clause 1. The assumption of original jurisdiction by the High Court for trial of a criminal case is a question of law which needs to be determined by this court, particularly in the light of universally recognized principle and a fundamental constitutional right in Pakistan pertaining to the due process. 26. At the relevant time, the Evidence Act 1872 was in field and Article 164 of Qanun-e-Shahadat order was not on the statute book. The learned High Court, while conducting the trial in hand, did not take into consideration a material fact that prosecution was not in possession of any evidence of conversation between the approver and the appellant. Surprisingly, this fact was also ignored by the Supreme Court while appraising the evidence in appellate jurisdiction. 27. I may make it very clear that coalition government headed by Pakistan People's Party is neither interested in any type of vengeance against anybody, nor the government believes in revenge. However, unprecedented incident of judicial murder of an international face of Pakistan's twice elected Prime Minister and father of the first Muslim woman Prime Minister and the father-in-law of the President of Pakistan, also twice elected and the founder of the largest democratic political force of the Federation, cannot be left unchecked under the dictates of justice, fair play and history, hence this reference.
Now, can we go to the relevant orders that you were referring to?
My Lord, if my Lords may kindly turn to order dated 21st of April 2011.
G.
The President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts.
Who was representing the President of Pakistan?
My Lord, it was Mr. Babar Awan at that time.
He's not representing Mr. Farooq.
During the course of proceedings, what happened? He was representing the President in this case.
No, is he here in the courtroom or no?
He was representing the government at that time. Then his license got suspended.
No, okay.
His license got suspended.
Is he present in court?
No, he's not in court.
Okay.
Now who is representing the President?
The Attorney General.
Attorney General is the President.
Who will argue the case?
It is for the government to appoint any counsel.
At that time, the government chose to appoint Mr. Babar Awan as the counsel. And during the course of...
He was not Attorney General.
He was not, man.
Right.
And on 12th of January, while his license was suspended, on 12th of January 2012, while his license was suspended...
No, that's irrelevant.
Another matter.
Okay, now, please proceed.
Now,
please proceed. Yeah. I just wanted that clarification. Please proceed.
The facts and the President of Pakistan has forwarded the instant reference under Article 186 of the Constitution. The facts...
ये जो question बने, ये अब तो कुछ supplementary reference है, उस reference पे तो question of law कोई नहीं है. बजाय, ये कैसे बने ये question?
My Lord, in continuation of ये इससे पहले जो orders हुए थे, if I may read the order, it so appears that the court didn't perhaps made the same observation at that time which my Lord has just made, and then pursuant to that observation, these questions were then forwarded, and they were reproduced in this order. The facts and circumstances.
The picture, see, Awan filed this review, this reference, and for 6-7 days he was addressing this court. People who are friendly to me, they said, Mr. Kusuri, why don't you go there? I said, this can't proceed without me. Let court call me officially. Eventually court called me officially, and I filed about 80 pages.
Mr. Kusuri, I hope you don't mind. They just want to continue with the Attorney General, and then
80 सफ़े का रिमाइंडर दिया, जब वो ने उसको क्वेश्चन बना के उसको पुट करना शुरू किया, he lost his temper, and court ने उसके 2 साल के लिए उसका लाइसेंस कैंसिल कर दिया, because he had nothing to answer. He was wobbling. He was short of answer. See,
let us hear the Attorney General Ji.
How's that man sitting?
My Lord, if my Lords may kindly turn to the previous order first.
In a very odd manner.
What is the date of previous order?
18th of April. I think this then answers why the questions were then forwarded and why they are recorded in the order dated. If my Lord may kindly turn to
let's go to this order you are saying.
So first, if I may take you to order dated 18/4/2011 and then to 21st April's order. 18th April's order.
18th April.
Yes.
because this is where I think the question arose, which questions have been referred to by the President. The learned counsel argued the case on the preliminary points relating to the questions of law in terms of Article 186(1) and 2 of the Constitution and needs further time to dilate upon the matter, adjourned to 21/4/2011. Now I'll read 21/4's order, 21st April's order. The President of Pakistan has forwarded the